Welcome to Law Pulse YouTube channel. Today, let us discuss about the classification of administrative actions. The administrative actions normally depends upon the three organs of the constitution, that is legislative and executive and judiciary. Usually the legislative actions, the statutes and the acts are amended and enforced and promulgated by the parliament and the state assembly as such, and then they are the lawmakers. The laws are legislated in the assembly, and the judiciary, the role of judiciary in the administrative actions are it interprets the law. If the law is defective, it strikes down. And the other important wing of the constitution is the executive. The function of the executive is to implement the laws and the statutes made by the legislature, either by the parliament or the state assembly as such. So these are the important the divisions or the classifications under the administrative actions as such. Then let us have a look the need of the necessity of this classification of administrative action. The fundamental rights, it ensures the rights to all the citizens of the country. Rather, whenever the fundamental rights gets infringed, then that will be questioned before the constitutional courts, that is the high court or the supreme court, under article 226 and under article 32, in order to get the principle of natural justice and the justice as such. So this is the aim of the classification and necessity of this administrative actions. So broadly here we can say the administrative actions can be classified based on the nature of power exercise. These classifications help determine the procedure to be followed and the applicability of judicial review or natural justice. So broadly, the classification of administrative actions depends upon, or it can be eliminated as quasi legislative actions, that is rule making action, quasi judicial action, and executive or purely administrative action, and ministerial action, and then discretionary and mandatory action. Now let us go one by one what is this classification says. Now first we will discuss about the quasi legislative action. What do you mean by this quasi legislative act? This is nothing but the rule making action as such. The meaning of this rule making action is it involves the making of rules, regulations, or bylaws under the delegated legislative authority. So, the delegated legislative authority is nothing but the one of the important administrative authority, and the delegated agencies or the delegated persons or the organs gets the power from the parental legislation as such. So, it is legislative in form but done by the executive rather. Then the futures of this quasi legislative action are it is general in nature, prospective in operation or in action, no obligation to follow natural justice. And for this, the best examples are the framing of rules under the Environmental Protection Act. Here, the Environmental Protection Act basically done by the parental legislation, either by the parliament or by the state legislature as such. And again, for that act, the regulations and rules are framed by the executives, by the administrative agencies as such. For this quasi legislative action, the case laws are, we can say, the AK Kriyapak versus Union of India, that is AIR 1970 Supreme Court, page 150. So, in this case, it is clearly established that it is distinguished between the administrative and quasi judicial functions. The delegated legislation held to be quasi legislative function as such. So, this is all about the quasi legislative action or the rule making action. Now, let us go to the quasi judicial action. What do you mean by this quasi judicial action. The administrative authorities, like a court, while deciding the specific rights of individuals, requiring adherence to the natural law of justice. That is the principle of natural justice here. It is very important rather. And then under this process of the principle of natural justice, here the very important feature is principle of hearing, giving an opportunity to the person express his opinion or to express or to say his words before the court of law, whatever it is. And also it includes the adjudication and then application of mind and reason mandatory. Here, the appropriate reasonability is very important, and also the application of mind is also very important. So, all these powers, all these processes will be exercised by the quasi judicial organs and agencies to dispense justice as such. Here, the best example for this quasi judicial action is the initiating the disciplinary proceedings against the person who is held liable, whatever it is. And then the cancellation of license after hearing, if at all the license issued by the administrative authorities is not according to the principles of law, then the quasi judicial action or the quasi judicial authority certainly passes an order of cancelling the license which was already issued by giving the fair opportunity and hearing all. So, this is the example in general, and the relating case laws for this quasi judicial action is Regent Baldwin, and it emphasizes the natural justice in administrative decisions. And also, the best example for this quasi judicial action in Indian law is Manekha Gandhi versus Union of India, which was pronounced during 1978 by the Supreme Court, which says the impounding of passport held to be quasi judicial, requiring a fair hearing. That means to say the due process of law is necessary. Before the passing of any order, the procedural laws, the due process of law have to be followed, and it is mandatory. So now we will go to the third classification of administrative law, that is the purely administrative action, or we can say the executive action as such. The executive action is nothing but which involves the implementation of law and policy where no duty to act judiciary exists. That means to say the futures are it is discretionary in nature, no requirement of personal hearing, subjected to limited judicial review only if arbitrary, modified, etc. The best examples for this purely administrative actions are the transfer of government servants. That means to say the executive has that power to initiate this kind of process against the public servant. So this will be vested with the purely administrative persons or authorities as such. And also the grant of government contracts, and then the implementation of welfare schemes. That means to say even the elected the government which is elected by the people and also in the form of legislature is also an executive in this regard. So sometimes the government, which is the political body which represent the political body which acts as the government, so have the executive powers, and all these features and examples relates to the elected government as such. So the best case law for this purely administrative action is the state of Punjab versus Gurdayal Singh, that was pronounced during 1980 by the Supreme Court. And here in this case, the main observation in this case is the land acquisition must be fair and non-arbitrary, even if administrative in nature. So this is all about the purely administrative action as such. And then coming to the fourth classification of administrative law is ministerial action. What do you mean by this ministerial action as such? It is nothing but a routine or clerical actions performed as a statutory duty without any discretion as such. The future says no discretion is involved. It is mandatory on fulfillment of conditions, can be enforced by a writ mandamus as such. such. Here, the examples are the issuing of certificate, either it may be a birth certificate or a death certificate, issuing of a passport, if at all a criteria is not followed or met, and the best law example, case law, is no specific litigation court treat as enforceable when official fails to act as. And then coming to the final, the classification, we can say the discretionary versus mandatory actions. Sometimes the administrative authorities have the discretionary powers, and also sometimes it is bounded by the statute of law. So it can be said under this a tabular form as such. You are witnessing and you're looking at this tabular column. So in this tabular column, it has been classified that the discretionary actions and the mandatory actions. The nature of discretionary action, which purely based on the authority's judgment, and under the nature, the mandatory actions are bounded by the statute of law as such. The examples for the discretionary actions are granting subsidies. Of course, the subsidies, it is vested with the administrative authorities. Either the subsidies can be granted to the particular community or person, or it may not be granted. This is called as the discretionary action. Whereas under the mandatory actions, the issuance of license for the fulfillment criteria. For example, if the government or the executives lays down certain principles, rules, regulations, it is the obligation to the citizen to follow the rules and regulations to get the licenses as such. If it is not followed and it is violated, then the authority has the mandatory power to cancel the license. Or if the citizen or if the individual fulfills all the principles, rules, and regulations, then the question arises that the administrative authorities have to issue the licenses when all the criteria and principles have been fulfilled according to the law. And then all these things can be again reviewed by the judicial authorities as such. Always the judiciary have the authority to review the actions made by the administrative authorities. If the authorities exercised the powers arbitrarily, then the judicial wing or the judicial authorities will certainly review it and passes an order. And even the courts gives the directions, issues the mandamus to the authorities to follow the rules, or sometimes even the judiciary has the authorities to set aside the orders issued by the administrative authorities, and also it directs to set it right the defective clauses or whatever it is. So this is about the discretionary and mandatory actions under the classification of law. The best case laws for this is the Ram Javaya Kapoor versus State of Punjab. This is AIR 1955 Supreme Court. So in this case, the Supreme Court especially observes that the executive can take action where law permits, scope of discretion is defined. So this is all about the classification of administrative actions and the functions of administrative authorities and its conclusions rather. The